Takes just a second to get that working. Okay, that looks good. Beautiful.
Yeah, like I said, we're glad to be here and glad to be talking about land use statutes. Remember back when people could meet in groups? Rick and I have spent the last week sort of listening to the audio and watching the meetings for the legislative session, and it's so sort of jarring to see all these people in person. I mean, look, all those people up in the rafters. Even life is very different now. I spend hours of my day on Zoom, which I wouldn't have expected or predicted a few weeks ago.
Yeah, to Marcy's point, so we'll be talking about changes that have happened over this legislative session, but I think the thing to keep in mind is we need to keep our eyes peeled for upcoming changes. It seems that all of the priorities are different now. You know, just within a couple of months, you know, what the legislator's funding, what they're not, and you know, public policy. Those all seem to be in a fluid state. So we'll go over the changes that have happened, and then we'll look out to the future.
So first, we'll introduce ourselves. As said earlier, both of us are attorneys with the Office of the Property Rights Ombudsman. I'm a former land use planner. I spent several years as a land use planner and as a real estate investor before going to law school. And I'm just an overall real estate junkie. I've always been interested in real estate and the laws that govern real estate and that govern cities and how those property rights. And I'm an overall real estate junkie always.
So I am Richard Plentz. I'm the newest attorney to the office. I just started earlier this year. As far as, you know, interest to the audience at hand, I did spend quite a bit of time clerking with city attorney's office, and but in general, I've coming out of private practice for the last few years, just general litigation, and also a court rostered mediator. So spent a lot of time doing mediation, and I guess maybe a little bit too much time mediating because I always tend to try to get all of my clients to settle out of court. And so I decided to just leave the litigation game and just come straight to being a mediator full time and working with the Ombudsman's office and trying to keep people out of court. So so it's an ideal situation, and we're happy to do the service that we were able to do.
So that's us. Now let's talk a little bit about what our office does. We're a neutral, nonpartisan agency. We help individuals and government agency, and yes, that means you, whoever you are. So if you're a member of the public, you represent a member of the public, you're government attorney, or perhaps you're a mayor or councilman, city planner, we're here for you. We help people understand and comply with land use and property rights laws. We help resolve property rights dispute. We advocate fairness and balance, particularly where private property rights conflict with public needs. So our office, most of our duties fall into three main categories. The first is we answer land use questions, and that can be to anyone that we can serve. So any member of the public that I just went through, anyone who works for government, anyone who represents anyone doing either of those things, call us with your land use questions. Either we'll know it because it's a frequent enough question that we've heard it before, or we can do a little research and get back to you. The second thing we do, again, is spend about a third of our time is mediate eminent domain disputes. That's a job that the legislature has given us, and it's something we do quite often, and I think we're very effective at it. I understand from UDOT, for example, that UDOT has the lowest condemnation rate of any Department of Transportation in any state. And while they're doing an amazing job, I'd like to think that part of it is they have us as a resource to help resolve those disputes. Property owners have us as a resource to go to when they have questions and can feel heard and really understand the law. There's a lot less chance of needing to go to court then. You can resolve things amicably when everyone understands what their rights are and they're being protected. And then the third thing we do is we issue advisory opinions. And I really believe it's an effective dispute resolution tool. It's a flexible way to get legal questions answered. Property owners or government agencies can request advisory opinions. Some government agents haven't known they can do that, but they can. We have a real reputation for solid legal analysis, and it's often a very effective non-binding solution that we can offer people. So now let's jump in the 2020 legislative session and all of its special sessions that haven't stopped yet. So many relevant changes to be aware of in the 2020 session. And some of those changes, as Rick has already said, they've already tried to tweak. So let's be vigilant about sort of sneaky bills that come up in the next few weeks. So new land use laws, let's jump in and talk about land use related laws that are passed this legislative session. I'll be taking the first half of the bills we'll go over, and then Rick will jump in and take the second half. And the first one, we're going to start with the one that is about us, about our office, the Property Rights Ombudsman Amendment, House Bill 273. This was the second amendment, is the one that passed, and included some significant changes from where it began. I'm told it was 3 years in the making, and it threaded the needle between the interests of involved parties, and it leaves the current process by our office for advisory opinions in place, and it doesn't weaponize the Ombudsman's office, as I understand that some folks were worried about. It's intended to deter bad actors without opening up cities to awful consequences. So the nuts and bolts of this bill. So if all of the criteria are met that I'm going to read below, the loser now pays a $250 a day fine, which those with a calculator will see it's $91,250 a year. So if all the criteria, the first is the court needs to resolve the dispute. The second is in a way that's consistent with an advisory opinion that's been issued on the same facts and circumstances. And three, I'm the substantially prevailing party in the land use applicant. The substantially prevailing party is the land use applicant or the government entity. So you can't have a third party that would get these that would receive these this fine. And the court finds that the opposing party knowingly and intentionally violated the law. And that to me is the really important portion of this bill. It's intended to be the highest standard. It's supposed to be extremely rare. Currently and historically, winners have been able to get attorney's fees awarded in sort of similar situations. And as far as we're aware, attorneys have been awarded in only a couple of cases. So it really is intended to encourage people to come to the table and to disincentivize bad actors on both sides. Note that $250 a day, that clock starts 30 days after the advisory opinion is issued or the lawsuit's filed. That gives people the chance to resolve things. It gives them a 30-day window to turn things around. If maybe they didn't know that they were in violation of the law, it gives them a chance to fix things. This way, note too that this doesn't waive government immunity, so that cities or governments, municipal governments, are opening themselves up to compensatory damages, which can be very difficult to control or predict. And it allows cities to make those difficult land use decisions without worrying about compensatory damages. And note though that this fine can be awarded to either the municipal government or to the land use, to the private property owner. It's not just intended as to deter cities. And so some property rights attorneys might think the bill means this, but as I mentioned, it's actually quite rare. The takeaway is advisory opinions issued by the Ombudsman's office that now have some more teeth as a deterrent to bad actors, and pay attention to those advisory opinions, act quickly where needed, and then even if you've done something illegal, if you get it cured, then that fine won't apply. Keep those fine seekers, don't give those fine seekers ammunition to file the lawsuits. So the second one I'm going to talk about is House Bill 306, the Planning Commission amendments. And maybe you remember where the Marvel series merged Spider-Man and Moon Knight into one hero into Arachnite? I don't either, but the next bill is somewhat similar. The takeaway here is that counties with more than one planning advisory area, they can dissolve each and then establish a single countywide planning commission by ordinance. This wasn't something that the state statute clearly allowed, but now you can. And in the discussion, they discussed, can you have a county planning area that has areas that aren't contiguous? And that's still fine. The areas don't need to be contiguous. This again is rare. All of the bills or most of the bills I'm talking about today are only going to apply sort of rarely. This only applies to a couple of counties. As I understand it, is Weber County that had 2 planning districts, one of them in the Ogden Valley and one in the western part of the state. And a good deal of the property or the population in the western planning district has or soon will be incorporated. So it no longer justifies having separate planning districts. They wanted to dissolve and merge into the remaining, and they just needed state statute to clearly allow for that. So now it does. The next one I want to talk about is House Bill 224, the dedication of public highways. And this one, Utah has a roads by use statute you probably are familiar with, which provides that if the public uses private property as a thoroughfare for 10 years, the public is automatically granted a permanent road easement. And the easement is granted to the public free. There's no compensation that's necessary. And no intent to allow this on the part of the property owner is required. That easement that the city or the government receives, it's wide enough for safe travel based on historical use, and usually includes somewhat of a shoulder on both sides. So the private property owners who want to stop new roads from being created on their property, they need to interrupt the use so that there can't be this 10-year public use fulfilled. And here's the wording of the statute itself. The roads by use statute provides that if a highway is dedicated and abandoned to the use of the public when it's been continuously used as a public thoroughfare for a period of 10 years. So the property owner's got to interrupt that use if they want to keep this from happening. In the old way, they needed actual interruption. That means they need to establish they actually stopped someone from accessing their property. So if they put up a barricade and someone moved the barricade and came through anyway, or went around, or if no one happened to show up that day or that week, or then it wouldn't be interpreted as actual interruption, and that's kind of tricky to document. You got to sit out there and document that someone tried to come by and you stopped them. The other troublesome thing was the highway authority could demand that the barrier be removed. And to many people, this felt like an abuse of power, because if you barricade your road to stop it from becoming public, and the public, an agent of the government can come and require you move that barricade, the government can get roads for free wherever they want. And I don't know if that's what's intended, but that's the way, once the law was put together, that's what it was in effect. So the new way, attempted interruption is enough. And any overt act reasonably calculated to interrupt the regularly established pattern and frequency of public use for 24 hours automatically stops that, restarts that 10-year clock. So if you put up a barricade for 24 hours, that's going to be enough, even if someone comes and goes around it or removes your barricade. You do need to do it when the road is used. If it's just a road that's used, say, for snowmobiling and no other part of the year, you can't put up your barricade in July. You've got to put it up when it's reasonably calculated to interrupt sort of the regular pattern of use. And they've deleted the highway authority's ability to demand that barriers be removed. And sort of it's a way of protecting private property owners, but it's still, note that it does not apply to roads which have already been created. Particularly RS 2477 roads, they're specifically unaffected, but any road that's already been established. So for instance, you can't barricade an existing right-of-way and have it revert back to private property. If it's a public right-of-way, the way to get that to go back to private, that road needs to be vacated, and that's a very specific process that includes a public hearing and some other steps. So those are the changes there. Yeah. So yeah, the takeaway there is an overt act intended to disrupt the public use of private property, it restarts the 10-year clock, and authorities cannot ask you to remove the barricade on private property. So next I've got 3 annexation bills, and then I'll turn things over to Rick. 3, I wouldn't have expected annexation to be such a hot topic. I believe it's the the most bills on one topic of any that I've looked at least. The first one I'm going to talk about is House Bill 305, Urban Development Amendments. And it's basically first-class counties now must give notice of proposed development to cities. If the development is within their expansion area and it's 50 acres or more, it's only for rezonings. It's not for site plans or subdivision. It's just for rezonings of 50 acres or more. They need to give notice and then give cities 90 days to either consent or object to proposed rezonings. And if they're silent, then after 90 days, it moves forward. And second through sixth class or specified counties, they've been doing this already. It's expanding that to include Salt Lake County, which has been treated historically a little bit differently, because up until about the 80s, Salt Lake County had a huge percentage of the population in the county in unincorporated county areas. But as new cities have incorporated, like Harriman and the like, West Valley City, it's not the case any longer. So rezonings in the county really affect some cities. So there we go. And okay, the second of my annexation bills is the municipal annexation revisions. It's House Bill 359. Rick, I think you're one slide ahead of me. There we go. So unusually, this is something that's rarely permitted in other states. It's pretty uncommon, but in very certain circumstances, you can create islands of unincorporated or peninsulas of unincorporated areas. That's if all the parties agree. So traditionally, cities could only annex, or towns could only annex property if it was contiguous to the city's borders, and the annexation couldn't create a peninsula or an island. It just caused problems. But under this bill, if all the parties agree, and that means the county needs to agree, the affected city needs to agree, the property that's being annexed needs to agree, and the property that's left as sort of the island or the peninsula, they need to agree. So if all the parties agree, and the annexation, the purpose behind it is the provision of municipal services, then they can go ahead and do that. Note this only applies to specified counties. So it's the second through sixth class counties. It's not going to apply to Salt Lake County. And there's also part of this bill allows certain annexations without a petition in a very, very narrow set of circumstances. And there was no discussion on the record about this annexation, so I'm not entirely sure what's driving it. I'm guessing there's a specific set of circumstances, and this applies to one of you, and that you guys already know about it, and almost won't apply to anybody else. But basically, if a city wants to annex some property that's in a neighboring county, which is within 2 miles of the municipality and publicly owned, or at least a portion of it's publicly owned, and doesn't include urban development, they can annex it in. So my next slide, and this will be the last bill that I'm going to talk about today before handing things over to Rick, the third annexation House bill, and that's House Bill 393, Municipal Annexation Amendments. And it has two parts. The first is sort of a no poaching, no more poaching. It makes it so an area that's requested an incorporation study, and while that study is being done, it can't be annexed in neighboring jurisdictions. I guess in some situations, neighboring jurisdictions, once that study had been filed for, were sort of cherry picking the best or the most profitable areas out of that study area. And that really, in many cases, prevents the local citizens from determining their own form of government. Because once the incorporation study is requested, if certain areas are cherry picked out, particularly if they're the tax generating areas rather than the areas more expensive to serve, they need to stop and do a new incorporation study, and sometimes it's no longer financially feasible. And annexations are quite a bit faster than incorporations. So now it gives the study incorporation sort of breathing room to determine their own destiny. And if what they determine they want to do is annex, they can, or incorporate, they can. It gives them some breathing room to do that. The second part of House Bill 393 is the municipal annexation agreements. And this is really about where you have unincorporated islands that are in 2 or more cities' annexation plan areas or town annexation areas. It requires them to work it out. Right now, it's sort of a race to the finish. It's in some inherent conflicts in the current system, and it's resulted in some lawsuits. So now they need to really work together and work it out. And if they can't, then it'll go to a vote. So the takeaway there is annexation, the new annexation rules are, play nicely. It's sort of the rules we learned in kindergarten, play nicely. I will add one more that an honorable mention in this third special session, Senate Bill 3008. There's already an effort was put forward to try and limit some of these new annexation changes. That one didn't pass, it didn't make it very far, but I would keep my eye open if annexation issues are important to your community or to property owners in your area. Keep an eye out. It looks like this is surprisingly a hot topic. And with that, that ends my portion of the presentation. I'll hand things over to the other half of land use bills, but I'm here for questions at the end if that's what we have. Thanks.
Thanks, Marcy. So I'll talk about some more bills that we had, and I'll start with what seemed to be kind of the most interesting to some people this session was yurts. So if you're not familiar with a yurt, this was essentially an example of a yurt. It's basically somewhere in between, a tent and kind of a solid structure. If you've ever heard of or gone glamping, that's essentially a yurt, depending on the setup that you had there. Here's another picture of a yurt, and you can kind of see just how tricky this might be sometimes, and whether this is considered, a temporary structure or a permanent structure. They've become kind of a very popular recently, and they were kind of a hot button topic, in the last year or two, just with the Utah area and kind of the housing crisis we've been experiencing and looking for affordable housing options. It's, whereas we used to think of this as kind of just a camping measure, it's, cities and counties have become concerned about increasingly, trying to use this as housing options. But so obviously with the setup of these, you can see that they can be fairly substantial. And so the question arises, how do we treat yurts as far as building codes and fire codes and whatnot? And, not wanting to be too restrictive on somebody's ability to go and do this for a recreational purpose far away from civilization. This bill was meant to address remote yurts. So here's some more pictures of yurts. Okay, so this bill introduces remote yurts into the state code. Yurts it defines a yurt as kind of a membrane covered frame structure. So you've got a firm structure, and it's covered with a canvas or some other, I guess, more soft material. It's a non-pressurized building. And then for remote yurts specifically, that will apply to these new regulations, you can already see just by the definition, kind of the restrictions that's going to place. So it can't be more than 710 square feet. It can't be used as a permanent residence. So this is, addressing, kind of a recreational use or a temporary use. And it has to be located in unincorporated county area that's not zoned for residential, commercial, industrial, or agricultural use. So already that's going to leave a narrow set of circumstances that this new statute's going to apply to. So if you've got, critical environmental zone or some other recreational zone that's not used for these purposes, that's what this is going to focus on. And then it can't have plumbing or electricity. It has to be at least 300 feet from any body of water, which will also be quite limiting. And then they have to register with the local health department. So if someone has a remote yurt that fits all of these requirements, essentially what this bill does is it exempts it from the state construction code, including building permits. It exempts it from the state fire code as long as they have a fire extinguisher on premise. and it also exempts them from the Water Quality Provisions Act, as long as they have some sort of what's called back county waste containment and disposal system. So they've defined that here. You'll see the definition is backcountry waste containment and disposal system means a pickle pail, rocket box, tube toilet, Johnny partner, or similar container used to collect and carry out waste, including fecal matter. So we've got that now in the state code. We now have a rocket box and pickle pail is now part of our state code. So there were jokes to be cracked all around when this was being discussed on the Hill. So that's what the bill does, is it makes these exemptions. However, it still allows counties to pass an ordinance that requires remote yurts to comply with all three of these. It has to be building code, fire code, and water quality act if they choose. So essentially what it does is, for remote yurts that meet these circumstances, it now establishes the default is that they're exempted. However, if the county still wishes to subject them to those safety codes, then it can do so by ordinance. The next bill, we had a couple of eminent domain bills, so I'll go through both of those. The first is House Bill 198, eminent domain limitations. Again, this is going to be a very specific and limited bill of application. It only applies to first class counties. So essentially right now, Salt Lake County, but as we all know, Utah County is well on its way in the next few years to probably reach first class status. So this will eventually apply to Utah County, but it applies to the use of eminent domain specifically for a park, and it applies or prohibits that use on a century farm specifically, and defines what that is. So a century farm is a farm that's been owned by the same family for at least 100 years and is currently being assessed as a century farm. Many of you are probably familiar with this painting called American Gothic. I looked it up. It was painted back in 1930. So essentially, this is dealing with a family farm that's been around longer than this painting. So it's a limited circumstance, and it seemed pretty clear that this, was addressing a very specific situation that arose. And so we now have a new law because of one scenario. Not that I can confirm or say for sure, but when I'm listening to the hearing audio, they had a woman that was from a family farm. Her family had a farm for several generations, and she spoke in support of the bill. So out of curiosity, I kind of looked up their family farm and saw they had about 35 acres of family farm property, and right in the corner, down in the corner, there was 2 acres that was kind of cut out of that was now owned by the city. And so whether this was because of that specific circumstance, I can't really confirm or deny. I'm sure people here that might be involved in that situation might know, but essentially this is a limited bill that might apply to very few scenarios. But if you are in Salt Lake County or eventually Utah County and you have any knowledge that you've got some century farms that would apply, just know that you're not going to be able to use eminent domain to create a park. So the other thing this bill does is it just kind of generally cleaned up the existing prohibition language on using eminent domain for recreational trails or for parks. And that was because there was another bill introduced that session, House Bill 261, that was aiming to do that. And so they essentially just morphed that into this bill that was passed through. So it borrowed that from another bill. And then that's in contrast to, there was one other eminent domain bill along these lines, House Bill 133, that was essentially the opposite attitude, going the opposite direction, that it was attempting to allow the use of eminent domain to be used for a regional trail system. So if you wanted a trail system to go, whether it be past Utah Lake or up along the mountain range, and you had both jurisdictions pass resolutions saying that they were going to use eminent domain and wanted to do that, this was going to make an exception to allow eminent domain for that kind of a recreational use. But that bill, you had essentially 2 bills going 2 opposite directions in the attitude of what's proper for use of eminent domain, and this is the attitude that went over the session. So Here's the actual language from the bill as far as defining what a century farm is. And here's kind of the language they used to clean up. The next eminent domain bill is for substitute Senate Bill 205, eminent domain modifications. This was a bill that was put forth, drafted by attorneys with UDOT. It's meant to simplify the eminent domain process for UDOT as far as pre-litigation procedures. Of course, it'll still apply to any use of eminent domain, so I think it's important that we go over it for cities and counties. But it essentially deals with when you have multiple interest holders in a single property, you know, who gets what slice of pie and what size, essentially is, I mean, it has some nuances that I'm not going to spend a lot of time on because I think these are very rare circumstances that these might come up, but it's more dealing with trying to simplify who does UDOT have to negotiate with before litigation. So as you're all aware, so the current process, if you're going to use eminent domain, here's essentially the spark notes of how that goes. I mean, you have an obligation to make a reasonable effort to negotiate with the real property owner before starting condemnation action. That includes that you have the property appraised before negotiating, and the owner has a chance to walk the property with the appraiser. And then based on that appraisal, you determine an amount that's reasonably believed to be just compensation that can't be any less than the lowest approved appraisal. And then you make a written offer with that amount to the property owner before any attempt to start an eminent domain action. And then, of course, as early in the negotiation process as practicable, you have to provide the property owner with material that is published by our office that explains what their rights are and what we can do in the Ombudsman's office to help resolve the dispute without the use of eminent domain. So that's the current framework, right? So what this bill does, well, the question then becomes, so what if you've got a situation where you have multiple interest holders in the single property? A common thing would be leasehold agreements or commercial leases, and you've got a long-term tenant that's been established in a particular property. And so if you've got a partial taking that's going to remove an access to a parking lot or something like that, that's going to have a big effect on the leaseholder and not just the person who owns the underlying property. Or you can have easement holders, or you have people who own some other right to the property, such as mining or some other water rights. So the question is, the way the statute is written now, it just makes a reference to owner or property owner, and doesn't, I mean, it appears that would apply to any type of interest holder because, an interest in property is a property right, and you're a property owner essentially of that interest. And so what this bill did was kind of clarify the roles of those interest parties. So essentially now the process before litigation is the condemning entity has to negotiate with the fee simple owner only, essentially. That's kind of the requirement that it states in the code. So now you have the property appraised, and the fee simple owner is the one that has the right to walk the property with the appraiser. When you have the appraisal done, the appraisal needs to be measured by an undivided interest in the real property being acquired. So that would essentially mean that the appraisal is taking into account all relevant interests in the property and valuing what those are. This isn't really something that anyone here is going to have to do differently. I mean, this is really more of an evaluation question with appraisers, and appraisers are already essentially doing this, right? They look at the property as a whole and determine what the value is, but it defines in the code specifically that the appraisal has to consider all interests essentially. And then when that appraisal is done and you determine what the value is, you make an offer to the fee simple owner. So it doesn't necessarily say you have to make offers and negotiate with every single interest holder before litigation. It's UDOT's trying to kind of consolidate and who do they have to negotiate with. And when UDOT was proposing this bill, some of the points that they made in framing this was, they had run into situations where if you've got leases, UDOT was saying that they didn't want to be stepping into the middle of a business relationship between the property owner and a leaseholder, and saying that some property owners were claiming that their leases were proprietary and didn't want to give up leasehold information. So UDOT was simply saying, we don't want to get in the middle of these relationships, so we're going to just deal with the fee simple owner as a point, and then the other interest can be worked out. And so it does leave some questions as to so what about these other interest holders? What do you do with them before condemnation action? The one thing that it does clarify is as to the statute regarding our office, the obligation to provide materials from the Ombudsman's office does still apply to every interest holder. So in addition to fee simple owners, the condemning entity still needs to provide disclosures to interest holders, which the statute defines as a claimant, and a claimant means somebody that owns an interest in property and that is not a fee simple holder. And then it provides a new, because the statute already has, you have to provide it in the substantially following form, and gives some standard language, regarding our office's materials that say, you have the right to seek just compensation, you have the right to speak with the property rights ombudsman's office. So it essentially mirrors that for the disclosures required to be given to claimants, but it does kind of tweak the language, and then it says that your interest in property may be affected, may be impacted by the project, and you may be entitled to receive just compensation. And that merely reflects that sometimes people who have an interest in real property, depending on the type of takings action, if it's a partial taking, just because it's affecting a single parcel of property that might have multiple interests, doesn't always mean that other interest holders are going to be affected by the project. So it doesn't say you are entitled to just compensation because of this project. It clarifies that you might be, and so you're still entitled to speak with the ombudsman's office, and we're still able to kind of mediate those disputes if it's requested by the interest holder. And then the other thing to keep in mind for condemning entities, if you do start eminent domain action, as far as a motion to get occupancy, and the amount that you're required to deposit with the court, that you do deposit an amount measured by an undivided interest in the premise sought to be condemned. So again, that's going to be the property as a whole, including all interests. But really, the situation comes up very infrequently because, as it's been explained to us, I mean, most commercial leases, for example, have a termination clause that if eminent domain action is initiated, that terminates the lease, and so the leaseholder doesn't have any rights to just compensation. And so this doesn't come up very often. There's still some things that I think need to be worked out and might be challenged. And so what we suggest is, while it only requires you to reach out to the fee simple holder, I mean, I would inquire and make sure that you're aware of any interest holders that you might not be aware of. So if there is a lease that's not recorded, the only way you're going to know that information is if the property owner informs you that there's a leasehold agreement. And so still make sure you're inquiring and finding out anybody who might have a property interest, and then keeping those people in mind. If you are negotiating with just the fee simple holder and they're readily agreeing and you're going to settle, you're essentially excluding the other interest holders from the conversation. And so if you're concerned about that coming back at you in an inverse condemnation action, if you have any doubts, get us involved, and so we can talk it through. We're here to give you advice and analyze any actions that have potential takings implications. And then if you still run into trouble, you can suggest to the property to the interest holder that they can request mediation from our office, so we can officially get involved and mediate a dispute. But the next bill we'll talk about is House Bill 202, Local Government Nuisance Ordinance Reform. And when this bill was presented, it was it was said that they did a survey among several justice courts across the state, and they didn't say how many or which ones they did, but essentially the figure they threw out was they found that 58% of all justice court proceedings are residential property violations. That was a little surprising to me, but nevertheless, this bill was put forth as an attempt to remove some of these property use ordinances or violations out of the justice court system. And so what the language says is, so currently, I mean, the language says that a municipality or county cannot impose a criminal penalty higher than a Class B misdemeanor is what it had been, but now it says it's an infraction for specifically two kinds of violations. One is violations relating to an individual's pet. So your dog gets off its leash and is roaming the streets free. That kind of a violation, or the use of an individual's property. So I call this the unkempt lawn, types of ordinances. You've got too many weeds, or your grass is too long, those types of ordinances. These now cannot be greater than an infraction. The big exception it makes to these, there's the actual language, is that it can't be more than a fraction unless the violation is a nuisance and threatens health, safety, and welfare of the individual or third party, or the municipality has imposed a fine on the individual for a violation that involves the same residence or pet on 3 previous occasions in the last 12 months. So it still is allowing the local jurisdictions to kind of enforce kind of the troublemakers in this area, but essentially it's as kind of a default, they're wanting to keep, these types of, use of property violations out of justice court as Class B misdemeanors. It does not apply to enforcement of building code or fire code ordinances. But it does say that as far as ongoing violations, you can't issue more than 1 infraction in a 14-day time period for something that's an ongoing violation. So can't just be tacking on daily infractions for the same thing that is still yet to be remedied. So now we'll kind of get to the main feature of this session that we're always looking forward to, is the land use task force bill to kind of revise the LEDMA provisions. There were several things that this year's bill did. It defines adversely affected party for purposes of land use appeals. It clarifies planning commission duties. It makes changes regarding subdivision amendments. Clarified that vested applications and under county ordinances are not affected by the property being incorporated into a city, and includes changes to municipal utility easements. So we'll go through each of these one by one. So it adds a definition of adversely affected party, which now means a person other than the land use applicant who owns real property adjoining the property that is the subject of a land use application or land use decision, or will suffer damage different in kind than and or injury distinct from that of the general community as a result of a land use decision. So why did we need to add a definition? So in parts 7 and 8 in LEDMA that deal with appeals and district court review, there were several references to either adversely affected person or adversely affected third party or aggrieved party. So it's kind of consolidating all of those into the same term. And at the same time, for those parts specifically, there were some times where it was only referring to like the land use applicant, but not referring to the adversely affected party. This clarifies that in each of those steps of the process in appeals and district court review, the rights are the same, right, for either parties. So if someone's losing an appeal and they want it reviewed, either can have that reviewed. But one thing to kind of point out is the use of or. So we all know that if you've got subparts and you use the word or, we're talking to the exclusion of the other, either one satisfies. So this essentially says that an adversely affected party can mean, if we only look at subsection A, adversely affected party is a person who owns property adjoining property subject of a land use application. So if you're the immediate neighbor of someone who has a land use application or is the subject of a land use decision, just by being the immediate neighbor, you are now an adversely affected party. And so that becomes relevant when you've got this provision about enforcing land use ordinances. Essentially what it says now is, before a municipality or a county or an adversely affected party now may, in addition to other remedies, institute injunctions, mandamuses, abatement, or other applicable actions. And so so the question becomes, is this going to just open the floodgates for private enforcement of zoning violations against a neighbor, where you're considered to be adversely affected just by being a next door neighbor? I think that, what it does is it allows these people to have standing, but it doesn't necessarily change, what they have to show to receive relief. So, there might be more claims filed if people understand this to mean that they can now sue their neighbor to enforce a zoning violation if the city or the county has not done it on their own. But I'm sure that there's going to be plenty of 12B6 motions to dismiss or summary judgment because, keeping in mind what the court's looking at, to provide any type of injunctive relief, they're still going to be looking for some sort of damage or injury that's peculiar to that person. So just because your neighbor is violating the zoning ordinance by itself doesn't necessarily mean that you've been injured. And that's also true because this bill didn't eliminate 802 subsection 1B that says that the municipality or the county need only establish the violation to obtain the injunction. So that's all. If the city is the one enforcing the zoning violation, they only have to show that there's been a violation. They don't have to show any particular injury, but that's not the same for a private enforcement. And so there's been a case in point on that analyzed that language when it was introduced in 2001 that said that while the cities and counties, only have to show a violation, private individual, they still have to show that there's been special damages peculiar to him or herself. And so I don't think it will really change the ability for, a next door neighbor to privately enforce zoning violations successfully. It might result in some more attempts to do so. But okay, so one of the next things that the bill does, it clarifies planning commission duties. This is more or less just cleanup language, maybe just making things more uniform if other jurisdictions had been kind of, finding carve outs that the planning commission wasn't involved with. So this clarifies that planning commissions are to be involved in reviewing and making recommendations on things like subdivision and amendments to regulations. It adds that the planning commission holds a public hearing on these issues, and that the legislative body is free to either adopt or reject those recommendations. And that this is something that I believe is a new addition, or I don't know if it was removed somewhere else, but it says the legislative body can consider planning commission's failure to make a timely recommendation as a negative recommendation. Next thing it does is it makes changes regarding subdivision amendments. So there's a new definition of subdivision amendment, which essentially means an amendment to a recorded subdivision that vacates all or a portion of it, alters the outside boundaries of the subdivision, changes the number of lots, alters public right-of-way, public easement, public infrastructure, or alters a common area. So essentially any change you have to a recorded preliminary plat for a subdivision is now considered just a subdivision amendment. There was language before that essentially said a petition to vacate or amend. This now just says it's all just a request for a subdivision amendment as far as the process goes. And so it adds that upon filing a written request to request a subdivision amendment, they now just have to record a plat that just focuses on what the change was. They don't have to reinvent the wheel and do a whole new plat. It's just, they just have to record what the change was and describe what the difference was between the original plat and the new plat. The bill also clarifies that vested land use applications with the county is not affected by subsequent incorporation. So this one's pretty straightforward and makes a lot of sense in my opinion. That as far as vested rights, so any land use applicant that submits a complete application and it complies with the ordinances at the time it's submitted, that applicant is vested as to their rights to that development against a later ordinance change that might try to prohibit that. So all this says is that likewise applies in the situation where under county ordinances an applicant vests and then that property gets incorporated into a city, and now the city is essentially the land use authority in charge of this application. This simply says that those vested rights don't change because there's been a change in government, essentially. And then finally, it includes changes to the municipal utility easements. So it enacts this section 529 that says that a public utility may exercise each power of a public utility if the specific public utility uses an easement with the consent of the municipality and that is located within the municipal utility easement described in, and essentially provides or an updated definition of municipal utility easement. That's basically now says that, essentially cleans up some language and clarifies that it's used or occupied with the consent of the municipality in accordance with an authorized franchise or other agreement and is used or occupied with a specific public utility. It might be a duplicate, but it's located in utilities and granted for public use or described in that section. And so one last bill that I want to mention is not directly on point with land use, but I think has kind of a precautionary tale about some of the decisions that you make as in cities and counties as far as the use of fees. So transportation utility fee amendments. So we all know in Utah, we've got quite a perpetual challenge with, getting funds for things like roads. And so transportation, so this bill is probably the shortest change of any of the bills that we saw in the session. And so it only removes 2 words from the code. So you ready? So here's the entire bill. It just removes the words or tax from the definition of transportation utility fee, which a transportation utility fee means an ongoing regular fee or tax, as it used to say, imposed by a municipality for the purpose of maintaining public roads and on utility customers within the municipality. So why did we need this change? Why did we have to remove the words or tax? Well, it was specifically because of just, I think, 1 week prior to this bill being introduced, a judge in the 4th District held that a city's transportation utility fee was actually an illegal tax. I think relying on what the statute used to say, and that a transportation utility fee could be essentially a fee or a tax, the city in that case had relied on the statute saying that that was a fee and not a tax, or could be a fee or a tax. And so rather than going through the additional kind of procedure to enact a tax, they defined it as a fee. And essentially the court in that decision said that, whether it's called a fee or tax, you look to determine whether it is, you look at what the fee does. And so they determined that because, the fee was charged to utility customers, but it was, used for public roads, which was a benefit that was a general benefit used beyond those that were paying the fee, it was clearly a tax. I understand that the city is currently appealing that decision. And I think, the legislature's attempt to simply just remove or tax from the code doesn't really do much to change the court's analysis. So I think that this is still subject to challenge in the future. So the cautionary tale is that, if you are looking for sources of funding, and this applies to things like impact fees, which we all know is very regulated, and you have to be very careful on how you treat things like impact fees. You have to look at what you're trying to accomplish with the fee and be careful about how you're framing it, just because you call it a fee doesn't always mean that that's the way it's going to be interpreted by courts, and it might be subject to challenge. So I think that concludes all of the bills that we saw would be helpful for you guys to know. If you have questions, we'll answer some questions now if we've got time, but you're also welcome to contact us at the office, and we're free to chat through some of these things with you. So.
Wow, Rick, Marcy, that was an awesome summary. I am blown away by the amount of material that came out of this session or sessions as we've gone along. Folks, if you have some questions, please type those into the chat box and we'll make those available. One that's already come up is if the slides from the PowerPoint could be made available, and Marcy's already answered that. She'll make those available, or Rick will, to me, and I will email those out to everybody who has signed up for the webinar. So thank you very much for making those available. Let's see, and go ahead and type those questions in the chat box. I had a couple that I jotted down as we were going along. Marcy, going back to establishment of public roads, is delivery of a public service like picking up garbage or something like that, is that a means to establish a public roadway?
It can be part of it, yeah. I mean, if the public is using, if it truly is just the sanitation folks, then maybe you could argue that instead they're going towards a prescriptive easement for just the sanitation folks. But if the public is using it, you had it somewhat intermittently, as long as it's regular, that would serve the regular continuous use for a period of 10 years. I don't know that just a sanitation truck once a week would cut it.
Okay, great. Looking for questions. I expected quite a few questions on the annexation side of.
Yeah, I was surprised it was such a hot topic. I'd like to go look at recent cases and see what sort of started all that.
Yeah, I think there was one in Davis County that was related to that Century Farm situation that I think was there. Oh, that was another one. I while I'm waiting for questions, I ask all of my questions. On that Century Farm part of Eminent Domain, would all of the parcels in that Century Farm have to be part of the farm for 100 years?
Well, that's a good question. You know, I don't think that the bill really addresses that. So, I mean, you're talking about an instance where there is a family with a Century Farm, but they might have divided the parcels over time. And so the creation date of a particular parcel, you're wondering if that parcel has to be created for 100 years?
Yeah, or additional parcels that were brought in, say a family started with, 160 acres in the 1800s, but then over the years they've added additional parcels. Does that parcel that they purchased in 1950, is that included within that Century Farm umbrella?
Well, so I mean, we've got the language here. I mean, the plain language just simply says real property that is assessed under this Assessment Act. So maybe, going to that Assessment Act and seeing if that provides any answers, that might help. But otherwise, I would think that each parcel would have to qualify for the 100 years, because that's all the language says, is it's just real property that is owned by the same family or contiguous family for 100 years. Oh, mm-hmm. So
great.
That's a good question. All
right. I'm just looking here. I'm totally flabbergasted that we don't have questions, because there was a lot of stuff. You must have done just an incredible job. There we got one that popped up. Rob wanted to make sure he got one in before we wrapped it up. A dirt road is used by the public for 50 years, and the landowner decides to install and close a gate, leaving it unlocked. The municipality cannot demand he open the gate, and he gets to interrupt until the court decides. I guess that's more of a statement than a question, or.
So I disagree. My understanding is that once it's been continuously used for a period of 10 years, it is automatically abandoned to use by the public. A judge would formalize that. So if you wanted to have sort of it formalized and be a matter of record, you could get a quiet title action to get that official. But it's still that roads by use. It's a highways dedicated and abandoned to the use of the public when it's continuously used as a public thoroughfare for a period of 10 years. It doesn't say and a judge has acknowledged it. So anytime after that's established, you could demand, it's a public road, you can demand that they remove the gate or give you a key to the lock. Or
and it's not the most recent 10 years either. You know, any
Right.
period of 10 years, once you hit that 10 years, then it essentially has been established.
Correct.
Okay, very good. Well, looks like that's the questions that we have. Oh, there's one more. Do roads by use includes trails, footpaths, bike trail, etc.?
They do. It's a thoroughfare. So bike trails, ATV trails, sheep trails, it all would follow the same as long as it's being used as a thoroughfare by the public for a period of 10 years.
You know, I think the question that arises there is always the scope, right?
Correct.
So, you know, just because there might have been a very narrow bike path doesn't necessarily mean that you've essentially now established a 3-lane road or 3-lane highway, right? It's, you know, whatever the traditional scope of that easement is what is established as a road. So
it's allowed for safe travel based on historic use. So if it's been used as a walking path or a bike lane, the public is acquired, say, 6 feet or 10 feet, not 60 feet.
Great. Thank you so much for taking the time to prepare this great presentation here. Just want to remind everybody that's watching today that the Ombudsman's office is available, and they've put their maybe Rick, if you want to put that final slide up there with your contact information. They are a great intermediary in a lot of these situations, and if you have a challenge, you know, just a question, I have found them to be great resources to call up and just say, hey, what about this? And that's why I take the opportunity when we're on here to ask my questions. Let's see. Do you have a couple of minutes for another question?
Yeah, sure. We're here. Let's do it.
Let's see. According to this slide, I'm not sure which one we're referring to. The new way says the highway authority cannot demand the barrier be removed. Oh, okay.
So it can't demand the barrier be removed while it's private property and before that 10-year clock has run. So anytime in the intermediate period while it's still private property owners can do what you know, within the bounds of the law, what they will with their property. After the 10-year clock has gone and the public thoroughfare is now it's now public. Now the police can demand, because it's public, so they would have authority to demand the gate be removed. Does that answer the question?
I answered it for me. We'll see what Rob's.
Yeah, in the old way, they could demand it at any time, even before the 10-year clock could run.
An annexation question related to annexation of property included in an incorporation. The new law appears to state that annexation cannot happen if the incorporation study is ongoing or the incorporation has been applied for. It appears that the law leaves a period of time between those actions that annexation may occur. Do you agree?
I wasn't looking for that when I read through or when I listened. That isn't something that came up in the discussion that they were intending to do. I would say the incorporation, once it's been once the study has been applied for, I wouldn't read it that way, but I'd want to go back and see. So I can't give you a definitive answer on that. In the discussion, that wasn't the intent, clearly. The intent was clearly to leave it in the hands of those citizens for them to decide the form of government that they would have and to give them some breathing room to get that completed.
Okay. One more quick question, then we'll wrap up. Back to roads. Is it required to be a physical barrier, or is posting private property sufficient? Or, and I'll add to that question, if you physically walk out and say, whoa, you can't come in here.
You need to, it needs to be a physical barrier, or it needs to be an attempted interruption. Just signs up that say it's private property is not sufficient. That in a court of law, it could come up as sort of evidence that the property owner did not intend it to become public, but that's not enough. You need to have sort of attempted interruption, which the physical barrier to me is the most obvious way of doing that. I'd have to think for a while to see if there are other ways of doing it, but just blocking the road for a period of 24 hours is sort of the standard.
Mm-hmm. And thus we see every year the roads in the BYU campus
Mm-hmm.
and churches all over the state are blocked off access to the property, just in trying to keep that.
Yeah, usually on Christmas Day, I think.
Mm-hmm. Yeah. All right. Thank you so much for the time and detail that we have here, folks. Make sure you're utilizing the Property Rights Ombudsman's office. They are a great resource for us, and we appreciate Rick and Marcy taking the time to present this for us today. Final words?
Thanks for having us. Glad to be here.
Yeah, give us a call.
Thanks so much, folks. Everybody go out, have a safe day. We'll wrap it up right now.
Bye-bye.
Yep.